Pierre, very good morning, and thanks so much for your time. Now, you've written about the lengths that the former president will go to avoid appearing before this very Commission of Inquiry, the Zondo Commission of Inquiry. And you've picked out some very curious developments or issues raised by Jacob Zuma's lawyers. Let's go straight to that and talk about why you think, or what you think they might be using to avoid him getting to court and getting to the inquiry.
Yes, so Mr. Zuma's lawyer, Yuveka, said that there might be a problem with the recent amendments to the Zondo Commission's rules or regulations, because these said that now the National Prosecuting Authority and the Hawks can get access to all the information that the Zondo Commission has gathered. And they say, well, this might implicate, or this might be a challenge. It might threaten Mr. Zuma's rights, so he can't testify. The problem there is that the testimony cannot be used in a court of law. It was never going to be able to be used in a court of law. So the recent changes doesn't change anything legally about the actual testimony. You cannot testify, you cannot use the testimony before Zondo in a criminal court, because you have a right to remain silent in a criminal proceedings. And so if you can use that, that would be a limitation on that right. And that's why the Commission rules say you cannot use it. So that doesn't mean that they might not challenge either the rule that says you have to testify, and if you're summoned, you have to appear unless you have just cause not to do so. But whether they will be successful in such a litigation is another matter.
So can that information, though, Pierre, be used by these authorities to launch a fresh investigation, to investigate anything they think where the former president is actually involved or implicated? Yes,
the original rules that President Zuma, just before he was recalled, so-called, promulgated, said that nothing that emerges from the evidence that emerged from the Zondo Commission could be used in a criminal court. That was obviously a nonsense, so it was amended. And any information, any evidence from other parties that are gathered, documents and so on, the Hawks and the NPA can now have access to that. They can use that to make their own investigation, yes. What they cannot do is they cannot just take the testimony that President Zuma will give, if he ever gets to the commission, and use that and say this means that you are guilty because you have incriminated yourself, or whatever the case might be.
So what are we to read into their reluctance, or in their using now this amendment to try and get out of appearing? I mean, for me as an ordinary person, I would say, so what have you got to hide then? Seriously, how does this change anything for you from when you came before this commission saying that you were a victim of conspiracy, that, you know, all of this was sort of meant to work against you? How does it change anything? And for me, as just an ordinary person, it means that you really, really have something to hide.
It would be a reasonable conclusion to draw. It is odd also because even in terms of the criminal law, if you are an accused person and the state makes a case against you, as all the witnesses who have implicated Mr. Zuma have done, and you then remain silent, the court said, well, just because we can then base our assessment on the evidence that is there. So if we follow the same rule for the Zondo Commission, whose rules are much more lax, it would mean that it's probably not in the interest of President Zuma not to give his version, because then the only version will be of all the people all the witnesses who testified against him and implicated him in wrongdoing. So it's an odd strategy unless you think that the strategy is really not about what the Zondo report is going to say about President Zuma, but if it is about trying to discredit the report and the commission and the process by saying, well, my rights have been infringed, and so regardless of what the facts might be, you mustn't believe the report that is finally going to come out.
So can he get away with it, Pierre? I suppose that's the obvious question at the end of this. Can he get away with continuing to find reasons not to get to the inquiry, not to get to the courts and other issues as well? Or will there be a point where the inquiry might say, listen, you know, now we'll have to take other drastic measures, or is that not within their ambit to do that? There's no way they can get him to come there.
Yeah, so the Commissions Act says that they can summon the president and then he's forced to testify. If he doesn't testify without having a good reason to do so, he will be guilty of a criminal offense. So, and a good reason is one where he and his lawyers will have to come with evidence to say, this makes it not possible for me to come and testify. I'm sick in bed, I'm in the hospital, whatever the case might be. But of course, that is not the end of the matter because, as I said in the beginning, they might challenge some of the rules of the Commission, and that will take quite a long time to resolve, and the Commission only has 7 months more to sit. So if they challenge some of the rules of the Commission or even the Commission's Act, the one that says that if you summon, you have to come and testify, they might not win the case, but they might delay it, and by the time that this is resolved, the Commission would already have had to hand in their report.
Okay, I suppose, again, he'll continue to avoid it until, will we ever get to hear the former president answer to all of these allegations against him? Thanks very much there. That's a constitutional law expert, Pierre de Vos.